Okay, thank you everyone and welcome to the second webinar in our Webinars Europe season, or series as I should say. In the 40 minutes that we have today, we're going to look at the following. First, we're going to look at exiting the lease. We looked on the last webinar at termination rights, but another way to potentially exit a property is of course to assign the lease or sublet the property. So we'll begin today by looking at assignment and subletting in each of our jurisdictions. Secondly, we're going to look at how we, as your legal advisors, make sure that your operational requirements for the property are met. That is, how do we make sure that the property that is let to you can be used for your business purposes? Thirdly, we're going to look at how we make sure that you have rights to use areas that are outside of the property, that are not let to you but are within your building. For example, most office leases will be part of a bigger building and you may require access or rights to use the roof space, delivery bays or parking areas, etc. Fourthly, what can you as a tenant do if the landlord does not rectify problems within the building? Obviously, it's key for your operations that any problems are fixed as soon as possible. So here we're going to look at what protections the tenant has or should have in its lease. Fifthly, we're going to look at what rights the landlord may have over the property itself and to see what, if any, provisions or protections are needed in order to minimize the effect of such rights on your business. Finally, we're going to consider what rights the tenant has to alter the property before and during the lease. So first of all, just a reminder of who we are. I'm Lisa Scharfenhoff, a consultant trainer here at Evershed Sutherland. I'm joined again by our local experts. So we have again Sebastian Wojcik from our Munich office, Virginia Thuy from our Paris office, and Annette Relou from our Amsterdam office. So thanks again, you guys, for your help today. Just a reminder that, of course, we're going to be looking again at our example remains, as per the last time, an office lease of part of a building in Berlin, Paris, and Amsterdam, where, of course, the demand for commercial space is high and landlords have a strong negotiating position. I will, of course, at points also refer to the London market in order to provide comparisons for you. So just another point, of course, that this will inevitably be an overview of the key issues. We only have 40 minutes or so today, but should you have additional questions, then please do get in contact with our legal advisors who will be very happy to help you with any additional questions you may have. And contact details will, of course, be provided at the end. So first of all, let's look at assignment or subletting of the lease. Now, in taking a lease, a tenant will want to know what options it has if, for various operational reasons, it no longer requires that space. So first of all, over to you, Sebastian, in Germany. Is it possible in Germany to assign or sublet a property?
Yes. In Germany, a lease can be transferred to another tenant by way of an exchange of the contractual partner. Such an exchange typically requires a tripartite agreement between the landlord, the old tenant, and the new tenant. In this agreement, the new tenant agrees to take over all rights and obligations under the lease from a certain effective date onwards. Assignment of the lease will always require the consent of the landlord, though. We would typically include in the lease agreement that such consent should not be unreasonably withheld, but this is hard to negotiate, and the landlord will try to define reasons, such as a comparable credit rating or a guarantee to be given by the old tenant for the new tenant. Something that can be achieved more easily, though, is to grant the tenant the right to freely assign the lease to a third party, which is a group company of the tenant. In such a case, this would usually have to be notified only to the landlord and would be condition precedent to the new tenant granting a lease security that is comparable with the one agreed with the old tenant already.
And that's obviously by way of assigning of the lease. Is the position different as regards to subletting, Sebastian?
Yeah, with regards to subletting commercial property, the situation is similar, since by law also this requires the consent of the landlord. However, the right to sublet are easier to agree, since the tenant will ultimately remain legally responsible for everything that the subtenant does in and to the property. So typically, the landlord is willing to grant consent in the lease for subletting, especially to specific group companies, and to accept that such consent for subletting may not be unreasonably withheld. A reason to withhold or to revoke the consent could, however, for example, be that the subtenant does not operate within the agreed purpose of the lease with the main tenant.
Okay, that's fairly clear. Thank you, Sebastian. Virginie, over to you. What's the position in Paris on an assignment, first of all?
Well, like in Germany, the assignment or the transfer of a lease also requires the landlord's approval. In practice, for office spaces, the transfer of a lease is very unusual, and this for two main reasons. Well, the first one is that the landlord will usually include a provision within the lease agreement that in the event of a transfer of a lease, the first tenant is jointly and liable with the new tenant for a period of 3 years from the transfer. Such provisions are authorized by French law, so it is nearly impossible to agree a lease without this kind of provision included. And secondly, you know, the landlords always prefer to have a new lease to be granted, since it enables them to negotiate a new rent or new conditions with the new tenant. So if a client informs us they want to transfer the lease, we would usually recommend the following. First, inform the landlord that the tenant is planning an early and amicable termination of the lease. It will require the landlord's consent. And then tell the landlord that the tenant will mandate an agent to find a new tenant or alternatively pay the cost of the landlord, instructing its own agent. Of course, this cost of paying an agent can be high, but it will be always less than having to continue to pay rent under the lease agreement.
Okay, so it seems that it's, as you said, that it's unusual to transfer a lease. The landlord will always want a new one. Is that always the case where it's a group company? Because obviously Sebastian talked about there being potentially more flexibility where you have group companies. Is there any flexibility on group company type arrangements, Virginie, or is it also difficult in Paris to allow for that?
Well, the landlord will always insist to have a new lease, even if it's a group's company. But when executing the lease on first time, you can include provision specific to group company and to assign a lease easily to them.
Okay, so you just have to think about it, obviously, when you're negotiating the lease to try and get that included.
Exactly.
And what's the position on subletting? Is the landlord more willing to do this, or is it also not so common in Paris?
Well, it is as complicated as the assignment. So subletting is also subject to landlord's prior authorization, and partial underletting is subject to negotiation with the landlord. Usually, the landlord will authorize the tenant to sublet 50% or less of the areas, subject to the tenant providing financial information concerning the proposed subtenant. The sublease of all space is never authorized. Indeed, if the landlord allows the tenant to sublet the whole of the property to the subtenant will have a kind of direct right against the landlord. In other words, this means that the subtenant will have the same rights or advantages benefiting to the principal tenant vis-à-vis the landlord. For example, the security of tenor we talk about in the first part of the webinar.
Okay, so for that reason, the landlord is usually against or will not allow a subletting of the whole, and it's got to be less than 50%, as you quite rightly said.
Yes.
Thank you for that. That was helpful. And we're going to move over now to Amsterdam. Annette, in the Netherlands, what's the position on assignment and subletting?
In the Netherlands, in almost all cases, a tenant may only assign the lease to another party after obtaining prior written consent from the landlord. When acting for a tenant, we will always try to stipulate in the lease that the landlord may not unreasonably withhold, delay, or condition its consent to an assignment. Most landlords will include language to the effect that withholding their consent will not be unreasonable if the new tenant does not meet certain criteria, such as the same credit rating or the same financial covenant strength as the existing tenant. Also, landlords are usually reluctant to accept intercompany assignments without the consent of the landlord. The method of assigning the lease is the same as in Germany. A tenant may only sublet the lease space to another party after obtaining prior written consent from the landlord. Again, we would look to include wording for the tenant that the landlord may not unreasonably withhold, delay, or provide conditions to its consent. Most landlords are willing to accept that the tenant may sublet the lease space to an affiliated party without prior approval from the landlord, since the main tenant remains responsible under the main lease.
Okay, that's very clear, thank you. So as you said, in particular, subletting is slightly easier in the sense of because the main tenant remains responsible, so the landlord's more likely to allow subletting than assignment in some ways. Let's then move on to our next point, which we talked about, is ensuring that the property meets your operational requirements. And if I may start again with you, Sebastian, in our Berlin-based lease, how would you make sure that the operational requirements of the tenant are met?
Thank you, Lisa. Well, first of all, the purpose of the tenant's business should be clearly described in the lease. The purpose given in a lease is in effect the landlord's guarantee that the property can be used for exactly such purpose. It is therefore very important that it's defined precisely. For this reason, landlords will always try to agree on a very narrow purpose, whilst tenants like to define this as widely as possible. An important case on this concerned a property that had been rented out to the tenant for the purpose of use as a dentist practice. The dentist practice used an X-ray machine which required heavy shielding to be installed to protect the neighboring properties. And the court ruled that the landlord was responsible for retrofitting the property with this shielding at his own cost. The landlord should have checked that the property was suitable to be used as a dentist practice, in fact, before guaranteeing this as a purpose of the lease. Had he done so, then he could have, of course, reached an agreement with the tenant as to the allocation of these costs. The landlord should also be contractually obliged to procure all relevant permits for the tenant's business under the so-called building and operational permit. And in such a case, if such consent were not obtained, then the landlord would be in breach of the tenant, and the tenant could terminate the lease. For bigger and more complicated projects, a tenant would usually also be involved in the permitting process and would be included in the discussions with the authorities in order to make sure that all their requirements are fully met and mirrored by the relevant operating building permit.
Okay, that's quite interesting, Sebastian, that the onus there, as you said, is clearly on the landlord to make sure that the property is able to be used for the purposes agreed in the lease, which, Annette, I think that the position in Amsterdam, like in London, is slightly different on that one, isn't it?
Yes, Lisa, that's right. In the Netherlands, position is very different in that the tenant has to check before entering into the lease that the intended use of the property is not limited or even prohibited pursuant to civil law and or public law restrictions applicable to the property. We would usually look at this as part of the investigation of title that I discussed in our last webinar. In addition to our investigations, we will also include a description of the intended use in the lease. It should be noted that this contractual permissible use may be more restricted than the use of the property allowed by public law restrictions. Tenants should be aware that the description of the intended use is not a guarantee from the landlord that the property can actually be used for this purpose. When acting for a tenant, we will always aim to stipulate that the landlord guarantees that the tenant may use the property for the intended use as described by the parties, but again, we do not always manage to get this guarantee included in the contract. It is advisable for tenants to include a description of the use that is as broad as possible here. This ensures that the tenant has flexibility with its use of the property, again, subject to the applicable civil law and public law restrictions.
Fantastic, thank you for that. And Virginie, over to you in Paris. What should the tenant do in France to ensure that the property can be used for its businesses?
Well, for one, this is a very simple point under French law. Since the landlord is, obliged to deliver the tenant a property that is compliant with the activity of the tenant as described in the lease agreement. It's kind of similar to Germany.
Okay, so in France, as you say, the landlord bears the risk on this one.
Yes, and for this reason, verification of the use of a property by the tenant is not usual. And as discussed in our last webinar, if the tenant is unable to use the property for the purpose mentioned within the lease agreement, then the tenant is entitled to terminate the lease and to obtain damages.
Okay, well, as you say, for once a straightforward point under French law there, which is good to know. And if we move on then, the other point that's obviously sometimes important for tenants is to make sure that they have rights to use areas which are outside of the actual premises let, but which of course they might also want to use, so parking areas, roof space for kit, etc. How do you ensure that the tenant is able to use areas outside of the property for the purposes of its business?
Concerning the areas outside of the property, if the tenant wants to use these, then they need to be included within the lease. If the use of such areas is included in the lease, then there will also be written restriction limiting the right of the tenant to the use of these areas. It is for this reason that the tenant does need to check carefully the description of the property in the lease and to consider if it has all the rights included in it. Under French law, the tenant can access the property 24 hours a day, except otherwise provided in the lease agreement or in the co-ownership documents. These co-ownership documents are the rules of a building owned by different owners, as the case may be, or if there are multi-tenants. This can affect how the tenant uses the property, so we will usually advise at the beginning of the negotiation that the tenant asks the landlord if the building has multiple owners or multiple tenants and obtain copies of the co-ownership agreement.
Virginie, are all the areas that the tenant would usually included in the description of the property?
Yes, but as I said, the tenant should always look carefully at the description of the property and ideally attach a plan showing all the areas to avoid any confusion.
And I think you actually have an example of where that happened to you once, where you had a problem with that, didn't you?
Yes, exactly. When one of our clients was using a storage area within an office building where he had a lease office. One day, the landlord claimed that our client had no right to use this room. It was a tiny room anyway, but when we checked on the room, we sadly, it was not mentioned within the lease, and obviously our client had to vacate the room.
Okay, so as you say, for purposes in France, to make sure that within the description of the premises that all areas used are included within there. Annette, if I can ask you the same question, is there a way of making sure within in Amsterdam or in the Netherlands that areas that are technically outside the premises can be used by the tenant?
Yes, in the Netherlands, any specific requirements that the tenant has for areas outside of the property should be identified by the tenant as soon as possible. We can then ensure that during the lease negotiations, these points are considered and that specific provisions are included in the lease. For example, tenants often require designated parking spaces. This may not always be possible, and sometimes a landlord will take the position that such designated parking spaces were not part of the negotiations. Furthermore, in the case of warehouse leases, which in the Netherlands will fall under the same regime as office space leases, tenants should be aware of the need for delivery bays and of the maximum load for any parking spaces.
Fantastic, thank you. And finally, Sebastian, over to you in Berlin. How do you make sure that tenants have rights to use areas which may be outside of the let area?
Yeah, typically the lease would always include a plan as an annex showing in different colors which areas can be exclusively used by the tenant and which are common areas. Once an area is dedicated as part of the lease, the law provides that the tenant has unless otherwise agreed, the sole right of use to such space, which also includes parking spaces, for example. Typically, the roof space of a building is not part of the leased property unless this is also specifically provided for in the lease agreement. For multi-tenant office buildings, the use of the roof by the tenant is harder to agree upon compared to a single-tenant office building or a logistics building. However, without such specific agreements in the lease, the use of space outside of the property, such as the roof, would be subject to the consent of the landlord, which can be difficult to be obtained with hindsight. So it's better to include it in the lease up front. In my experience, installing tenants' equipment on the roof, for example, solar panels, should be discussed with the landlord early on in the negotiations, as this will typically require different load-bearing capacities of the roof structure, hence structural enforcements, and potentially also holes in the roof, which might have an impact on the landlord's warranties vis-a-vis its general contractor of the building. So this definitely needs to be all discussed during the lease negotiations, because otherwise there's no right to external spaces.
And Sebastian, while we're talking about roof spaces, you actually have quite a fun fact that you've come across as to the use of roof spaces, haven't you?
Yeah, absolutely. Lately, we've also seen some tenants looking to secure not only the right to use the roof, but also the right to use the airspace above the building, subject, of course, to relevant permits being obtained. And this is to allow for drone delivery to the premises. This is sensible, really, since leases in Germany can be concluded for a fixed time of up to 30 years. So the tenant is, by this way, simply future-proofing its lease.
Yeah, as you say, thinking ahead, always good when you're negotiating a lease to think about how the property might be used in the future and to try and cover all rights. So sensible tenants in that regard. Let's move on, though, thank you for that, to look at the situation where we're dealing, let's say, with difficult landlords. So another question that can potentially come up is, what can we do if the landlord does not keep areas that the tenant's able to use in good repair? And Annette, if I can start with you, obviously the tenant has control over the areas that it's rented, but as regards the areas that are controlled by the landlord, what can the tenant do if these areas aren't being properly maintained, or if there are problems with these services that have been provided to them?
Well, each lease in the Netherlands should include extensive provisions to document the responsibilities of both the landlord and the tenant regarding maintenance and repairs. Parties are free to agree as they wish, and therefore we strongly recommend that tenants discuss these maintenance, repair, and renewal obligations during the negotiations. If a party does not observe these provisions, the other party has the right to take adequate measures itself and recover the reasonable costs from the defaulting party. These costs may be set off against the rent.
Okay, so that's interesting. So unlike in London, where you don't usually have these provisions, in the Netherlands you have what are called self-help provisions, in the sense that if something isn't repaired, then the tenant can go ahead, get it repaired, and recover the costs from the landlord. Is that correct, and is that a good thing for the tenant?
Yes, exactly. And these provisions encourage the landlord to keep to its obligations in the lease. But of course, it is a double-edged sword. Since if there is damage to the property, the tenant will also have its own responsibility to take adequate measures in order to limit the damage to the building as much as possible. And also, a tenant would want to limit the disturbance of its business.
Okay, yeah, fair enough. So if we move on then, Virginie, to you and what happens under French law, if we ask the same questions as to, how can the tenant protect its position where the landlord's not carrying out repairs, etc.
Well, as in the Netherlands, in France, leases should include extensive provisions concerning the obligation of the landlord and the tenant regarding maintenance and repairs. I can explain this better with an example. Once, our client, which was a fashion brand, contacted us because its landlord refused to perform the works required by law for the accessibility of the property, despite the fact this cost should have been paid by the landlord pursuant to the lease. Well, first, we send a letter by record delivery the landlord, requesting that the landlord remedy the issue within a specific period of time. Under French law, there is no time period set legally, so the landlord will usually resist adding this kind of provision within the lease agreement. Obviously, any such time period must be reasonable regarding the rectification required. In practice, we would recommend 1 month, and this is the time period we set in our notification. And less than 1 month later, the landlord performs the works. This is kind of happy end, but I have to admit that in France, issues regarding accessibility or works relating to safety are considered as very important works and are usually carried out very quickly when they are borne by the landlord. But if the landlord had remained silent or had not responded or did nothing within the time period, well, the tenant is entitled to sue the landlord in front of a specific court. We call it a juge des référés, in order to ensure that the landlord pays in advance for the cost of the works.
And am I correct in thinking, Virginie, that these kind of ability to sue for these works to be carried out is a relatively new thing under French law?
This point is not a new thing under French law. The new thing is that the law authorized for some kind of work the tenant to act in behalf of the landlord. But, you know, in all the lease with professional landlords, the landlords always withdraw the possibility of the tenant to act on his behalf.
Oh, okay. So, in effect, the lease itself will preclude the ability for the tenant to act on behalf of the landlord and just carry out the works.
Exactly.
Okay. Thank you for clarifying that one. And over to you, Sebastian. What's the position in Germany on this one?
Yeah, in Germany, the tenant has very strong remedies. So if the landlord doesn't repair areas, this would be considered a defect of the leased property, which would in turn give the tenant the right to either reduce the rent or to repair the property himself, offset the costs against the rent, or in very severe cases also terminate the lease contract. We also have some clients where making sure that the operational needs of their business are met is actually more important than the aforementioned remedies and rent reductions, or even a termination of the contract. And in such cases, the tenant can also sue the landlord for fulfillment of the contract. So the landlord could be forced in court to carry out the works.
That's really interesting. Thank you, Sebastian. I think, as you say, sometimes some of the remedies that you may think of, such as reducing the rent or claiming costs for carrying out works, don't satisfy the tenant because their operational requirements really need the business to be back running as soon as possible. So that's a very interesting point. Thank you. Okay, let's move over then to another point, which is obviously within the lease there will sometimes be provisions, particularly, as I say, in London, where the landlord will have quite a lot of rights that it retains over the property, for example, to carry out repairs to common services, etc. Are there any concerns, or what limitations would you include in the lease in your jurisdiction to make sure that those rights are limited? Because obviously the tenant doesn't want the landlord simply entering the property and potentially again interrupting its business. So first of all, over to you, Sebastian. Are there also strong rights in Germany at minimizing the rights for landlord to enter?
Yes. So the landlord has the right to access the property to fulfill, or for the purpose of fulfilling his contractual and legal obligations. So if under the lease the landlord is responsible for maintenance and repairs, then he would have to be allowed access for such purposes. However, this right can and also should be contractually limited by including notice periods and such things in the lease. The landlord may also request the right to inspect the property in order to find out if the tenant is in breach, or in order to show the property to potential future tenants towards the end of the lease. But we would always look to restrict these rights to the bare minimum by including notice periods and other restrictions. So we would typically include a prior written notice of at least 7 days, which names exactly the purpose of the specific visit. And we can also here ensure that sensitive areas of the lease object are excluded completely from landlord access, such as R&D rooms, MDS rooms as such. Secondly, we would also restrict the number of visits to 1 per month, for example, but not more than 6 a year, eventually more in the last couple of months of the lease. And thirdly, we would make the visit subject to those entering the property signing a non-disclosure agreement, which would ideally also be attached to the lease as an annex. So there's also some statutory protection in that the landlord may not use its right to enter the property in order to simply be a nuisance to the tenant, but in order to avoid what this is, and clear rules should be included in the lease.
Okay, so there's quite a lot of specific wording included in there, and as you say, depending on the sensitivity of the information that the tenant has, there are certainly things that you can do to agree with the landlord that certain areas are restricted or notices are given, etc.
Absolutely, Lisa.
Annette, over to you in Amsterdam. What's the position on this in the Netherlands?
In the Netherlands, the landlord has a right to access the property for the purpose of inspections, valuations, maintenance works, etc., but he can only do so after consulting with the tenant. If the parties have agreed that the landlord may enter the property after consulting with the tenant, but if the landlord fails to do so and just enters the property, then this will be considered as a breach of contract, unless, of course, in case of an emergency. The tenant may impose certain restrictions regarding timing, supervision, and confidentiality, and it is usual to include provisions to this effect in the lease agreement.
Okay, so in the same way Sebastian just discussed, you can include wording in there that obviously limits the landlord's right to enter, but it seems as though in the Netherlands there is a little bit more consultation with the tenant before they can just go in and enter the property.
Yeah, that's correct.
Okay, then over to you, Virginie, in Paris. What's the position in Paris on this one?
Well, under French law, the landlord offers the tenant a peaceful enjoyment of the property. But you know, it is very common that landlords add provision within the lease agreement by which the landlord or its contractor or agents are authorized to visit the property at any time. The landlord can carry out the works in the property without any limitation of time and without compensation for the tenant, or that the landlord can put signage on the facade or anywhere in the building. So like in Germany and in Netherlands, to avoid this kind of intrusive provision, we can try to modify the wording to minimize the effect.
Okay, fair enough. Thank you for that. And on then to the final point here, which is usually one that's important for tenants, is to alterations that they can carry out to the property either before or during the lease. So their initial, what we would call in London, fit-out work, so obviously to fit the premises out for the tenant's proposed use. And obviously during the course of the lease, if then alterations need to be carried out, what the restrictions are then on being able to change or alter the lease. And one of the first things that I would say is that in my experience, it's usually easier to get the landlord to agree to lots of changes to the property, where of course you have the, where you're negotiating the lease with them because they want you to enter into the lease. But later on, when the lease is granted, it can then be more difficult to get alterations approved. Is that also your experience, or what's the position on alterations in your jurisdiction? Virginie, if I can start with you on this one.
Yes, usually the tenant has to have the express prior consent of the landlord to carry out its work within the property, especially for signage, partitioning works, works with impact on the structure, the roof, or equipment. Otherwise, the landlord can request the tenant to remove the works carried out without authorization. For instance, one of our clients installed a very wonderful geometric floor tiles by a famous artist. He did not obtain the prior consent of the landlord, which was obviously required in the lease. So the landlord requested the removal of the tiles, which could have also led to a claim for the artist. We managed, hopefully, to negotiate the points afterwards, but it would have been much easier if the client had obtained the prior consent of the landlord for these tiles. If not specified in the lease agreement, the period time required to obtain the authorization of the landlord will depend on how quickly the landlord responds or of the clarity detail of the documents provided by the tenant to obtain such authorization. The key point for major points is that it is, of course, easier to obtain the consent of the landlord to works at the commencement of a lease agreement. In practice, consent is not an issue for simple fit-out works, subject to the requirement that the tenant provides to the landlord as soon as possible a description on plans of the fit-out works, which are usually an annex of the lease agreement.
Okay, thank you for that, Virginie. Over to you, Annette. What's the position in the Netherlands on fit-out works and alterations?
In the Netherlands, the starting point is that parties have contractual freedom and may stipulate whatever they wish. Usually in the Netherlands, we see that tenants try to negotiate, and usually the landlord accepts that they have the right to make changes or alterations to the property without prior written approval from the landlord, except for changes or alterations that may impact the structure of the property.
Okay, so the usual minor works are easier to approve, but the major alterations are the ones that cause problems.
Yes.
Well, not cause problems, but as I say, required approval.
Oh, yeah, well.
Either way, I won't infer problems there, Annette, so that's quite a straightforward point. And is it your experience, too, that, you know, if it's good for the tenant to consider what works it may carry out and to try and get as much approval before the lease is granted as opposed to trying to then go to the landlord for consent later? Is that what happens? Or is that your point in the Netherlands too? That it is, as you say, good for the tenant to consider what works it may want to carry out, and to try and get as much leeway in the lease as possible before the lease.
Yeah, exactly. It's obviously best to get as much to get as much flexibility before entering into the lease, because like was already said, if you have to try and renegotiate this during the term of the lease, it may be much more difficult to get this flexibility that you're looking for.
Absolutely, yeah. Thank you for that. And then finally, Sebastian, over to you on the same point about alterations.
Yeah, in Germany, it's easier to get the landlord to agree to certain works already in the lease, or at least to a general approach on how to deal with works or certain categories of alterations in the lease. It can be agreed that only structural changes will require the consent, or that any such consent may not be unreasonably withheld. Furthermore, certain de minimis levels for where consent is required for alterations can also be included. So for this, it's essential to know which consents are market standard and which are hard to agree. And as Annette just said, it makes a lot of sense to upfront already think about what alterations you might want.
Yeah, I think that's a very sensible and good point that we've made hopefully clear on that one. Well, thank you for your help today. If you do have any questions, as I say, we've given you hopefully an overview of the position on the various points that we discussed in our jurisdictions, but should you have any further questions, then our legal advisors would be happy to help you. I should go back to the initial slides, just swap back so you can see their names and details, but of course we can also forward that information to you so that should you want to contact our lawyers directly, you can see their names and who they are here, then of course you can happily contact them, and I'm sure that they would help you with any additional questions that you may have. But thank you very much for joining us on this recorded webinar today. Thank you to our presenters for making what's particularly tricky points very clear, so thank you to all of you. And yes, I hope you enjoyed that webinar. Do let us know if you have any suggestions for any further webinars, and thank you for your time in listening to us today. Thanks very much, everyone.